If you've ever been to a real estate closing, you might have noticed a curious sight at the end of it. Once all the documents are signed, the checks are exchanged, and perhaps the keys are turned over, there's one person who takes the signed deed and the mortgage if there is one, and then leaves immediately. That person is taking the deed immediately to the Register of Deeds office. That's because a land transaction typically isn't final until the deed is recorded. Until that happens, the buyer is vulnerable. An example of that vulnerability appears in the 1953 case of Messersmith versus Smith. Caroline Messersmith and her nephew Frederick Messersmith each owned a half interest in land. On May 7, 1946, Caroline quitclaimed her interest in the land to Frederick, but that deed wasn't recorded with the Register of Deeds until July 9, 1951. Before the quitclaim deed was recorded, several more transactions occurred. On April 23, 1951, Caroline leased the same land to Herbert Smith. Then, on May 7, 1951, Caroline signed a warranty deed granting Smith her half interest in oil, gas, and mineral rights on the land. She initially signed a deed before a notary who executed the required acknowledgment accompanying the deed. But later that same day, Smith discovered a minor error in the deed. So he returned to Caroline's home, explained the error, tore up the deed, and prepared a second deed, which she then signed. Smith then took that deed to the same notary who telephoned Caroline. She confirmed over the phone that she'd signed the new deed. The notary then prepared the standard acknowledgment for the second deed. 2 days later, Smith deeded his newly acquired mineral rights to E.B. Seal. The lease, the deed from Caroline to Smith, and the deed from Smith to Seal were all recorded in May of 1951, almost 2 months before Caroline's 1946 quitclaim deed to Frederick was recorded in July. Frederick then filed a quiet title action against Smith and Seal in the Golden Valley County District Court. Frederick argued that since Caroline had quitclaimed her interest in the land to him in 1946, she didn't have any interest to convey to Smith in May of 1951, and Smith therefore had no interest to convey to Seal. Smith didn't respond to Frederick's lawsuit, thus defaulting. Seal responded that since Caroline's deed to Smith and Smith's deed to Seal were recorded with the Register of Deeds before Frederick's 1946 deed was recorded, Seal's title to Caroline's half interest was superior to Frederick's. The trial court ruled that nothing about the notary telephoning Caroline for her acknowledgment invalidated her deed to Smith. Since the May 1951 deeds were recorded before the 1946 quitclaim deed was recorded, Smith's title was superior to Frederick's. Smith's deed to Seal was therefore also superior to Frederick's. Frederick appealed to the North Dakota Supreme Court.